They say the courtroom is a place of justice, but anyone who has actually stepped inside one knows the truth. It's a theater. It's a gladiator arena. And usually, the lions are fed well, while the Christians are slaughtered. My name is Ben Miller, and on the morning of October 14th, I was the Christian. I was 24 years old. I had passed the bar exam exactly 3 weeks prior. My suit was bought off the rack at a discount store, and the sleeves were slightly too long, making me look like a child playing dress-up in his father's clothes. I stood in courtroom 4B of the Superior Court, my hands trembling so violently that I had to grip the edge of the table just to keep them steady. Across from me sat Marcus Vance, the lead litigator for Omnicorp. He was 50, tanned, silver-haired, and wearing a bespoke Italian suit that cost more than my entire student loan debt. He looked at me with a bored, pitying smile, like I was a bug he was about to crush without even thinking about it. But the real monster wasn't the lawyer across the aisle. It was the man sitting high above us on the bench, the Honorable Judge Arthur Sterling. They called him the Emperor. He had been a judge for 30 years. He was legendary, he was brilliant, and he was cruel. He was known for shredding young lawyers for sport. If you stuttered, he mocked you. If you cited the wrong statute, he humiliated you. And today, he was looking at me like I was a waste of his precious time. "Mr. Miller," Judge Sterling boomed. His voice echoed off the mahogany walls. "Are we going to proceed today, or are you waiting for your mother to come hold your hand?" The courtroom erupted in laughter. The bailiff chuckled. The court reporter hid a smile. Marcus Vance didn't even bother to hide his. He laughed openly. I felt the heat rise up my neck, burning my ears. I tried to speak, but my throat was dry. No, Your Honor. I am ready." "You don't sound ready, son," Sterling sneered. "You sound like you're about to faint. Bailiff, keep the smelling salts handy. I don't want this boy passing out on my floor." More laughter. I looked down at my client, Elias Thorne. He was 82 years old, a retired watchmaker. He was sitting in his wheelchair, clutching a faded photograph of his late wife. Elias lived at Oakwood Manor, a historic retirement home that had served the community for 50 years. But Omnicorp had bought the land. They wanted to bulldoze it to build a luxury shopping mall. They were evicting Elias and 200 other seniors. They offered them peanuts to leave. Most took the money. Elias refused. He said he promised his wife he would die in that room, looking out at the garden they planted together. I was the only lawyer who would take his case. Everyone else told him it was suicide. You don't fight Omnicorp. And you certainly don't fight them in Judge Sterling's courtroom. Sterling and the CEO of Omnicorp played golf together every Sunday. Everyone knew it, but nobody could prove bias. "Your Honor," I stammered, opening my file. "We are here to request an emergency injunction to stop the demolition." Sterling rolled his eyes. He actually rolled his eyes. "An injunction? On what grounds, Mr. Miller? Omnicorp owns the land. They have the permits. They have the demolition crew standing by. Your client is a squatter, a trespasser." "He has a lease, Your Honor," I said, my voice shaking. "A lease that was terminated legally," Vance interrupted, standing up smoothly. "Clause 14B of the residency agreement allows for termination upon change of ownership. We gave Mr. Thorne 30 days. He has stayed for 60. He is delaying progress, Your Honor. He is costing my client thousands of dollars a day." Judge Sterling nodded. "Mr. Vance is right. The law is clear. Property rights are paramount. I am inclined to dismiss this motion immediately and order the sheriff to remove your client by noon." "No," I blurted out. The room went silent. "You don't yell no at Judge Sterling." He slowly turned his head toward me. His eyes were cold, hard flint. "Excuse me, did you just raise your voice in my courtroom?" I apologize, Your Honor," I said, forcing myself to breathe. "But you haven't heard our argument. You haven't seen our evidence." Sterling leaned back in his chair, crossing his arms. "Evidence? What evidence could you possibly have?" Did you find a magic bean? Did a fairy godmother tell you the mall is evil? He laughed again, a deep, mocking laugh. Listen to me, boy. I have been practicing law since before you were born. I know every statute, every precedent, and every loophole in this state. This is an open and shut property case. You are wasting taxpayer money. You are wasting my time. And frankly, you are embarrassing yourself. He picked up his gavel. I am dismissing this case with prejudice. And I am sanctioning you, Mr. Miller, for filing a frivolous lawsuit. $5,000. My heart stopped. $5,000. I didn't have $500. That would bankrupt me. It would end my career before it even started. Elias touched my arm. His hand was paper thin, shaking. It's okay, Ben, he whispered. We tried. Let's go. I looked at Elias. I looked at the picture of his wife, and something inside me snapped. The fear vanished, and it was replaced by something else, something cold, something sharp. I didn't move. Did you hear me? Sterling barked. Case dismissed. Get out. No, I said again. This time my voice didn't shake. It was steady, quiet, deadly. Sterling froze. What did you say? I said no, Your Honor. You cannot dismiss this case. Not yet. I can do whatever I want. I am the judge. Not in this case, you're not, I said. I reached into my cheap, battered briefcase. Not when you are a material witness. The silence in the courtroom was heavy, suffocating. Marcus Vance frowned. Objection. What is this nonsense? Sit down, Mr. Vance, I said, not even looking at him. My eyes were locked on Sterling. Your Honor, you said you know every statute and precedent in this state. You said you've been practicing since before I was born. That's true, and that is exactly the problem. I pulled out a document. It was old, yellowed, the edges were fraying. It smelled of dust and archives. What is that? Sterling asked. He looked nervous, just for a second. But I saw it. This, I said, holding it up, is the original deed of trust for the land Oakwood Manor sits on. Dated November 14th, 1984. Almost 40 years ago. So what? Vance scoffed. We have the deed. We bought it. You bought the deed to the building, I corrected. But you didn't read the original covenant attached to the land transfer from the city. I walked toward the bench. The bailiff stepped forward to stop me, but Sterling waved him off. He was staring at the paper in my hand. In 1984, I continued, my voice echoing clearly now, the city of Essex sold this land to the original developers for $1, a symbolic price. Do you know why, Your Honor? Sterling didn't answer. His face was pale. They sold it for $1 on the condition that the land be used in perpetuity for the care of the elderly and indigent. It's a restrictive covenant, a charitable use clause. It means this land cannot be used for commerce. It cannot be used for a mall. It cannot be sold for profit. If the building is demolished, the land reverts automatically to the city. Vance stood up, furious. That's ridiculous. Our title searchers would have found that. They missed it, I said. Because it wasn't filed under the property ID. It was filed under the Municipal Charitable Trust records. It took me 3 weeks in the basement of the Hall of Records to find it. I found it yesterday. I placed the document on the judge's bench. But that's not the best part, I said softly. The best part is the signature at the bottom. Sterling looked down at the paper. His hands were shaking now. Worse than mine had been. You see? I turned to the courtroom, addressing the audience, addressing the camera of the court reporter. The lawyer who drafted this deed in 1984. The young, ambitious lawyer representing the city who insisted on this clause to protect the elderly was a man named Arthur Sterling. Gasps. Actual gasps from the gallery. I looked back at the judge. You wrote this, Your Honor. You wrote the clause that bans this demolition. You signed it as the witness. Sterling stared at his own signature. The ink was faded but legible. Arthur J. Sterling, Esquire, so, I said, leaning in. You have a choice. You can rule that this document is invalid, but if you do, You are admitting that you committed legal malpractice 40 years ago by drafting an unenforceable contract. You would be admitting you were incompetent. I paused. Or you can uphold the document. You can rule that the covenant is valid, that the land cannot be touched, that Omnicorp has no claim. But if you do that, you upset your golf buddies. Sterling looked up at me. The arrogance was gone. The Emperor was gone. All that was left was a tired, trapped old man. He looked at Vance, who was frantically texting on his phone, probably calling his bosses to tell them the deal was dead. Then he looked at Elias, the old man in the wheelchair. "Mr. Miller," Sterling said. His voice was a whisper. "You are conflicted out, Your Honor," I said. "You cannot judge a case involving a contract you wrote. But before you recuse yourself, you have to acknowledge the evidence on the record. Is that your signature?" Sterling closed his eyes. He took a deep breath. He knew I had him. If he lied, it was perjury. If he admitted it, the mall project was dead. "Yes," he croaked. "That is my signature." "And does the clause state that the land must remain a sanctuary for the elderly in perpetuity?" "Yes." "Then, Your Honor, I move for a summary judgment in favor of the plaintiff. The eviction is illegal. The demolition is illegal. And my client stays." Sterling looked at Vance. "Counselor, do you have a counter-argument?" Vance slumped in his chair. He knew when he was beaten. "No, Your Honor." Sterling banged his gavel. It sounded weak. Hollow. Motion granted. The eviction notice is quashed. The demolition permit is revoked based on the restrictive covenant. Court is adjourned. He stood up and practically ran out of the courtroom. He didn't look at me. He didn't look at anyone. The courtroom was silent for a second, and then Elias started to cry. Not sad tears, happy tears. He grabbed my hand and squeezed it with surprising strength. "You did it, Ben. You saved us." I looked across the aisle. Marcus Vance was packing his bag aggressively. He stopped and looked at me. "You made a powerful enemy today, kid. Sterling will never forgive this." I smiled. A real smile this time. "Mr. Vance, with all due respect, I don't care." I walked out of that courtroom pushing Elias's wheelchair. The sun was shining outside. It felt different. The air felt cleaner. Judge Sterling retired 2 months later. Sudden health reasons, they said. But we knew the truth. The rookie had exposed him. The boy he laughed at had ended his career with a piece of paper from 1984. "I'm not a rookie anymore. My name is Ben Miller." And I learned something that day. Justice isn't about who has the most expensive suit. It isn't about who has the loudest voice. It's about doing the work. It's about digging in the basement when everyone else is playing golf. And sometimes, just sometimes, it's about reminding the powerful that they are not gods. They are just men. And men make mistakes. Even emperors fall.